exciting. We have a great event for you today. We have two esteemed professors and scholars to talk about the Second Amendment. But before we get into that, I'm going to turn it over to our president, Mr. Caleb Childers, to announce the 1L Rep election results.
Thank you, everybody. Thank you for participating, especially the 1Ls, as always, but particularly this year with the size of your class. Really high voter turnout. A lot of you ran, so thank you for participating.
Wait a minute, where were you on January 6th? Anyone been disqualified from the election for holding office? Just, I'm asking for a friend. People at Yale might want to know.
But thank you, appreciate it. If you didn't win, there's always other positions. You can still stay involved. And then there's other positions in the spring as well when the new leadership takes over with the new board. But congratulations to Adam. He's the winner. So thank you for stepping up. For the rest of you, please, stay involved. We'd love to have you on other committees and the like. But with that, I'll turn it back over to Ashley.
All right, so I have the privilege of introducing our speakers today. First, we have Mr. Josh Blackman. Josh Blackman is a national thought leader on constitutional law in the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials. He testified before Congress and advises federal and state lawmakers. Josh regularly appears on TV, including NBC, PBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, the Wall Street Journal, the Washington Post, and leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law in Houston. He holds the Centennial Chair of Constitutional Law. Josh is also an adjunct scholar at the Cato Institute. Josh has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Josh has written more than 6 law review articles that have been cited nearly 1,000 times. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Josh is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
You should all play.
He blogs at Bobolic Conspiracy and tweets at Josh N. Blackman. Our second guest is our very own Professor Brian L. Fry.
Who was not on Zoom last year. Last year, Brian was on the screen and behind the wheel, if I recall.
I believe, yeah.
And for those who took torts, that's a no-no. Duty of care.
Professor Fry joined the faculty of the College of Law in 2012. He teaches classes in civil procedure, intellectual property, copyright, and nonprofit organizations, as well as a seminar on law and pop culture. Previously, he was a visiting assistant professor of law at Hofstra University School of Law and a litigation associate at Sullivan & Cromwell, LLP. He clerked for Judge Andrew J. Kleinfeld of the United States Court of Appeals for the Ninth Circuit and Justice Richard B. Sanders of the Washington Supreme Court. He received a JD from the New York University School of Law in 2005, an MFA from the San Francisco Art Institute in 1997, and a BA from the University of California at Berkeley in 1995. His research focuses on intellectual property and charity law, especially in relation to artists and art organizations. Professor Fry is also a filmmaker. He produced the documentary R. Nixon.
Very cool movie. You got to watch. Seriously, it's a really cool movie. You got to watch this one.
In 2013, which was broadcast by CNN and opened theatrically nationwide. His short films and videos have shown in the 2012 Whitney Biennial, the New York Film Festival, and the San Francisco International Film Festival, among other venues, and are in the permanent collection of the Whitney Museum of American Art. His critical writing on film and art has appeared in October, The New Republic, Film Comment, Cineast, Census of Cinema, and Insight, among other journals. Additionally, Professor Fry also produces a podcast called Ipse Dixit. We thank you guys again so much for coming, and at this point, I'll turn it over to our speakers.
Thank you. Thank you so much. It's a pleasure to be here with my good friend Brian Fry, Paul Salamanca, in the UK chapter. In honor of Brian, I'll start with Nixon, right? What does Richard Nixon have to do with the Second Amendment? So you may recall that Richard Nixon made 4 appointments to the Supreme Court, including the Chief Justice. He appointed Warren Burger to replace Chief Justice Earl Warren. And at the time, Burger was seen as this conservative, right, to pull back on the sort of the excesses of the Warren Court. But Chief Justice Burger wasn't a fan of a broad reading of the Second Amendment. In fact, he gave an interview in the late 1980s where he said the idea that the Second Amendment protects, an individual right to bear arms was a fraud, was a scam. He described it as just this thing right-wing gun advocates made up. So again, this was the Chief Justice of the United States in the late 1980s. We've come very far from that. In the span of really a couple decades, the intellectual climate about the Second Amendment shifted significantly. And new scholarship was developed, arguing that, wait a minute, the Second Amendment, yeah, it mentions a militia, but also mentions the right of the people. And people started thinking, what exactly is it the Second Amendment protects? Now, usually when you ask a question like that, you say, what has the Supreme Court said about the Second Amendment? And in candor, not very much. Before 2008, the Supreme Court really hadn't said much. There was one case called United States against Miller, which Brian will talk about maybe a little bit later. It was a sawed-off shotgun, right? Well, the sawed-off barrel shotgun. And the court sort of made some comments about the weapons used in the militia, but they didn't really go into too much depth. There was another case called United States against Cruikshank from 1873. This is not a pleasant case. What happened was you had a group of African Americans in a town, and a lynch mob came after them. Now, these African Americans tried to use guns to defend themselves. And what happened? A white lynch mob forced them into a church and burned the church to the ground. And even those who escaped the burning church were shot dead, and the bodies were carried to a river. This was a gruesome massacre called the Colfax Massacre. And the perpetrators of this massacre were charged with depriving people of their civil rights, including the right to bear arms. And what did the Supreme Court say? The 14th Amendment had just been ratified, did not protect the right to bear arms. So there really wasn't much precedent about what the Second Amendment actually means. But we jump forward to the 1990s, and there were some opinions in district courts and in circuit courts saying, wait a minute, the Second Amendment has some weight. This is not about protecting the rights of states to have militias or about just making sure the federal government can't disarm people. This is a right that the people themselves have. And this came to a head in 2008. A case called District of Columbia versus Heller, very significant case. And by a 5-4 vote, the court held that the Second Amendment guarantees a right of individuals to keep and bear arms that is not connected to militia service. And as a result, the District of Columbia could not ban firearms altogether. At the time, the only one who had a firearm were those in law enforcement. In fact, Dick Heller, the lead plaintiff, he was a law enforcement officer. His job was to safeguard federal judges. He had a gun at work. When he went home, he's got to leave his gun there. Could not bring his gun to his own house. He actually had a gun in his home from the 1970s. It was a grandfather gun. If he had put it together, assembled it, he would have broken the law. Even if someone broke into his house and was threatening him, had he assembled his gun, he would be in violation of the law. So that, I know people may not like it, but that wasn't a terribly difficult case. You have an amendment saying something like guns, you can't ban guns. Okay, 5-4 still. 2 years later, we get a case called McDonald v. City of Chicago, right? McDonald considered the question of incorporation. Who's here taking common law yet? Mostly some of you. Okay, so the Bill of Rights, free speech, freedom of religion, so on. Originally, as it was designed, only restricted the federal government, right? Congress shall make no law. It's right there in the text. So as a result, if the state violated your free speech, too bad. Take it up with your state constitution. Go to your state courts. You can't go to federal court. This was a case of Barron against Baltimore. You probably say this the first week or two of common law. But after the ratification of the 14th Amendment, things sort of changed. And over the course of years and indeed decades, the court began to extend the provisions of the Bill of Rights to the states. This was called the incorporation doctrine. And it wasn't done all at once, so sort of done in bits and pieces. Okay, we'll incorporate this right, we'll incorporate this right. And before you know it, almost the entirety of the first 10 amendments applied equally as against the state and federal governments. There's a couple outliers, one of which to this day is the right to a jury trial, not been incorporated. Seventh Amendment. The Second Amendment was also an exception. Then we get to McDonald. And the court explains by a 5-4-ish vote, I'll explain why it's ish, that the Second Amendment protects not just rights against the federal government, protects the right against state infringement. That way, Chicago couldn't ban the possession of firearms in the home. I say ish because the court split on the rationale. 4 votes use what's called the Due Process Clause of the 14th Amendment, what's often derided as substantive due process. The idea that a liberty protected by the Due Process Clause is the right to bear arms, and it would violate due process for the states to deprive you of that right. That was 4 votes. Justice Thomas took a different path. He used the Privileges or Immunities Clause of the 14th Amendment. This is not well known. I haven't mentioned in class, but this was probably the right way of doing it. That was a clause designed to protect certain substantive rights, I think at least. But the bottom line is, after McDonald in 2010, the Second Amendment restricted both the federal and state governments. Now you would think, oh my God, Josh, didn't this change everything? McDonald and Heller? Nope. At the time, almost every government allowed possession of guns in the home. DC didn't, and Chicago didn't. That's it. So the effect of McDonald in Chicago and Heller was to really affect a very small number of jurisdictions. Most people didn't have any change unless you lived in DC or Chicago. The change would come through follow-up litigation with issues. For example, does the Second Amendment protect certain types of arms? So-called high-capacity magazines, so-called assault weapons. I'm saying so-called because these terms don't always have an obvious meaning. Does the Second Amendment protect the right to carry outside the home? Does the Second Amendment protect the rights of former nonviolent felons to carry a gun? Does the Second Amendment guarantee the right of not having to take extremely difficult training requirements? Where can you carry? Can you carry in parks, on subways, and different so-called sensitive places? So after 2010, there were a lot of open issues. And at the time, I sort of expected, and by the way, I graduated law school in 2009. So I graduated right when the stuff was kicking off. Right, Heller was decided my second year of law school. Actually, shortly after my second year of law school finished. So at the time, I think, all right, the Supreme Court will get around to deciding these issues, just give it some time. So it's 2010, 2011, 2012, 13, 14, 15, 16, 17, 18. 18? Yeah. Almost a decade went by before the Supreme Court decided another gun case. What happened was in every single case, the Supreme Court would simply deny review. They just wouldn't take the case. And they basically delegated to the circuit courts the power to enforce the Second Amendment. And I'll tell you, almost every circuit just about consistently ruled against the Second Amendment. There were only a couple decisions that actually ruled in favor of the Second Amendment. You know what happened? Those were not appealed upstairs. So in the District of Columbia, the DC Circuit, which at the time was kind of conservative, said, you have a right to carry outside the home. Did DC appeal that case? No, they did not. They were afraid of setting a national precedent. Seventh Circuit actually opposed their opinion. He didn't want to rule this way, but Dick Posner said, yep, Second Amendment protects the right to bear arms. We're bears there. Supreme Court, please reverse us, right? Supreme Court didn't reverse him because no cert petition was filed. So it was this game sort of keep away where the conservatives said, Supreme Court, take our case, take our case, take our case. And the court said, cert denied. And the gun control advocate said, well, we lost this one. Let's just leave it here. Forget Chicago. They got enough crime anyway. It doesn't really matter, right? And we'll let this one go. So it was this weird detente, this weird cat and mouse game where the court just denied. And then after a couple of years, Justice Thomas and eventually Justice Scalia started dissenting, saying, wait a minute. We have this thing. We have this Heller case. Why are we not actually doing something with it? Why don't we just review a case to give some guidance to lower courts? Deny. Scalia died, then Alito came along. But eventually, in 2018, the court finally took a case from New York. This was a remarkable case. New York actually made it a crime to keep a gun in your trunk locked unless you're going to another range, right? You couldn't just drive around with a gun locked in your trunk. You need a special permit, which, by the way, they wouldn't give you. Right? It was impossible to get this permit. So the Second Circuit upholds it. Say, yep, that's fine. Intermediate scrutiny, no problem. Cert petitions filed, certs granted. What does New York do? New York City do? This is crazy. New York City repeals the law that they defended below. And ready for this? New York State passed a law saying you cannot reenact this law. So it was literally impossible for New York to reenact this law. And they did this after the cert grant. Okay, you guys are all smart lawyers or lawyers to be. They were trying to move the case. And indeed they did, right? The Supreme Court said, okay, this case is moot. There's nothing for us to decide. They were so afraid of a court ruling that they went out of their way to just nuke the law. And they defended this law all the way, and they suddenly repealed it. What does that tell you? They were afraid of what the court would do. All right, so fast forward another year, another case from New York called New York State Rifle and Pistol Association versus Bruin, B-R-U-E-N, okay, like a bear. What is Bruin about? New York had what was called a May issue carry regime. May issue, what does that mean? You apply for a license to carry a gun outside the home. Maybe you'll get it. Maybe you won't. What does it depend on? Well, there's not really any standards. You have to show what's called good cause or sufficient proper cause. What would that mean? Well, are you friends with the sheriff? Right? Are you a politician? Are you a celebrity? All the celebrities, they get guns. Or are you just a regular person living in upstate New York who's afraid of crime? Oh, that's not good enough, right? A simple fear of crime was not sufficient to constitute good cause. You need something very specific. Even if you routinely handle large amounts of money for your business and live in a high crime area, that's not enough either. Again, and this is just to carry a gun concealed with you. This is not to carry any sort of large weapon openly. This is a concealed carry license. New York defended this law in the lower courts, and they upheld it. There had been a circuit split where the 7th Circuit and the DC Circuit said, no, you can't have this May issue regime. You have to have what's called shall issue, which means you apply for a permit, you get a permit. Kentucky constitutional carry now? Yeah, thank you. I'm glad people know this, right? So the other standard is what Texas has, what Kentucky has, where you don't need a permit. Just as a matter of course, you can carry a gun. I live in Houston, 4th largest city in the country. We do okay. But New York thinks they know better. Okay. So this case goes to the court. As you probably know from your common law class, the court ruled against the city of New York, against the state of New York, and they held that yes, the Second Amendment protects the right to bear arms. But what was significant was the manner in which they ruled. They said when we're deciding gun cases, we have to use analogies. We have to use analogical reasoning. Do you remember that from the LSAT? Does that ring a bell? Like if this is to this, is this to this, right? It's its entire mode of thinking, which you probably bury deep in your subconscious. The difficulty here, right? The difficulty here is what do you do with the analogy? Well, the court says there was not a very good analogy of in past times laws that required showing of good cause, right? There's no historical similarity of something that required you to not have a gun unless you have good cause, okay? There are some other laws that were similar. For example, there have been some laws in the past that said if you were shown to be dangerous, you might have to put what's called a surety or a bond before you could carry a gun. But the comment said that's not close enough because there's not necessarily a showing of dangerousness. So the court said, okay, using this analogical reasoning, the New York law is unconstitutional. All right. In the wake of Bruin, by the way, this is a 6-3 case. In the wake of Bruin, the lower courts have begun to consider what it actually means to follow this analogical reasoning. Okay? And the courts have sort of fractured. And this isn't just in a straight left to right divide. So I'll give you one example of a ruling that probably won't stand very long. There was a judge, I think in West Virginia, who had a case where someone had scribbled off the serial number in a gun. They just scratched it off. And the argument was, well, at the time of the framing, there were no serial numbers, so there's no analogy. True, literally, there were no serial numbers, right? And I'm not going to argue at that point. But you know, the idea of having a record-keeping mechanism does not seem a terribly substantial burden on any sort of right. It seems not too onerous, but you know, what do I know? So that's the sort of case that may not actually hold up. The other big case involves people who have engaged in criminal activity. Now, you may know this, may not. Generally, when you are convicted of a crime, you do lose a right, which is often the right to vote. Right? Felons are disenfranchised, and to get your voting rights restored, you have to go to your governor, and there's various processes, but it's actually not simple and not guaranteed. You don't lose your other rights, though. You don't lose your right to free speech when you have jail. You don't lose your right of religion. You maintain your other rights, but voting is different. What about guns? What if you've been convicted of an offense, or maybe you're not convicted, but even accused of an offense? Do you lose your gun rights? So I'll give you an easy example, right? Martha Stewart, right? The white-collar Duchess of New York, right? Who engaged in insider trading and obstruction and some other obstruction. But she was accused of insider trading, right? Okay, so they got her on obstruction. So basically a white-collar offense. She spent some time at Camp Pleasant, federal prison where they make doilies and whatever else. She would never harm anyone. She'd never harm a fly. She's lovely. Why can't Martha Stewart own a gun? Felony conviction. Right? What happens if you engage in Medicaid fraud? That is, you bill the government for too much money. What if you engage in food stamp fraud, right? Where you got too many food stamps, and that's a crime. Non-violent offenses. Can a person engage in non-violent offense be deprived of the right to bear arms for life, for their entire existence? This is a case that's come up and down to the court. I suspect the courts will probably say that perhaps a bridge too far, that a non-violent felon who has shown no propensity for harm cannot be disarmed. And indeed, there's really not a historical tradition of disarming non-violent felons. Now, just keep this in mind. You probably learned this in criminal law. At common law, what was the only penalty for felony? Death. So usually people convicted of felonies didn't really care about their gun rights because they were being executed. So there's perhaps a lack of history about people who were actually convicted of felonies and later lost their rights. Okay? All right, but what about violence? This is where we get to the case we'll be talking about later, called Rahimi. R-A-H-I-M-I. Zaki Rahimi. So he's a person from Texas, and this is not the kind of person you'd want to be friends with. And I don't say this to criticize him, but he has not a good track record. Rahimi got into an argument with his girlfriend in a parking lot. He knocked his girlfriend to the ground, and he dragged her back to his car, causing her to hit her head on the car's dashboard. And then in a telephone call after the incident, he called the woman. He said he would shoot her if she told anyone about the assault. Okay, so this is not your poster child of anything. A few months later, a Texas court enters what's called a domestic violence restraining order, DVRO, domestic violence restraining order against Rahimi. And the order also barred Rahimi from possessing a gun, and it warned him that doing so while the order was in effect would be a federal felony. What do you think he did? Do you think he followed the order? Of course not. About a year later, while the order was still in effect, Rahimi was a suspect in a series of shootings. He was never convicted of those. He was even charged with them. The police searched his home pursuant to a warrant, and they found guns and ammo and other things, and a copy of the restraining order. Right? So he knew about the TR of the restraining order, and he had a gun anyway. So then he was charged by the feds with possession of a firearm by anyone subject to a DVRO. And he pleaded guilty to prison and was sentenced to about 6 years in prison. Originally, his conviction was upheld, but after Bruin, the Fifth Circuit, where I live, Texas, threw his conviction out. Okay? And the argument was that there's not a historical tradition of banning people subject to domestic violence restraining orders from having guns. Again, there's no conviction for a felony. He was just charged with a restraining order. And I mean, you probably know this is not obvious, but in the 1860s and 1790s, there was no such thing as a domestic violence restraining order. That didn't exist. So if we take Bruin on its terms, then yeah, there's no tradition of this. And this sort of leads to where I want to wrap up, and bring up Brian in a few moments. The Bruin test was not advocated really by anyone, right? None of the litigants really asked for this analogy program. And when the court says text, history, and tradition, what does tradition even mean, right? If you've been doing it for so long, it's got to be legal, right? What does tradition add that text and history don't? So we're in this weird spot where not even most conservatives are defending Bruin. And I think we'll see in Rahimi how the court sort of tries to clean this up. I don't know how how the court cleaned this up, right? I don't know how the court sort of resolves this, but I think what we might see is some fractures. I think we might see some fractures in that the Chief Justice and Justice Kavanaugh and Justice Barrett are not comfortable with giving Mr. Rahimi, a man who violently beat up his girlfriend and threatened to shoot her, a gun. Just going on a limb there. I'm not seeing 5 votes for that one. But then the question becomes, what do you do with Bruin? And perhaps Bruin should have anticipated this issue, right? Justice Barrett, when she was on the circuit court, wrote an opinion in a case called Cantor, Kanter, Ricky Cantor, who'd been involved in some sort of government fraud, and she said he should have his gun. So I think the court might just say if this was a violent felony versus non-violent felony, that might make a difference. But that's sort of hard to define because what's violence? Violence against whom, right? How do we define that? Rahimi was not convicted of anything. He was just accused of engaging in violence, and there was no judge, there was no jury. So I think it's actually a difficult case for the court. Also, the case being litigated by a federal public defender, which is not to criticize them, but this is someone whose interest is not necessarily in the Second Amendment at large. His interest in getting his client off. So the test he advocates for his client may not be the best test for other gun cases. So the federal PDs are actually very eager on this case, but there is some schism on this one. Okay. No, I'm sorry. Let me explain this. There's no actual conviction for a domestic violence restraining order. What that means is you go in front of a judge, and they issue an ex parte order. But there was no conviction on this ever. I don't know if the case was dropped or what happened, but there was no conviction. I'm sorry? It was still in effect when he. No. Yeah. All right. I think I'm just about done. Brian, you want to chat for a bit? We'll get some chairs.
So, like sit,
Yeah.
have a conversation. So thanks for having me. Glad to be here, participating in this conversation today. And thanks as always to Josh for paying us a visit here in Lexington to talk about the Second Amendment. He's given, I think, a pretty thorough and comprehensive introduction to the recent jurisprudence addressing these various Second Amendment issues. And I go with any of the observations he's made about what the court has said, or really broadly speaking, sort of his observations about why the court, especially in its current format, has reached the conclusions that it has in relation to what the Second Amendment means and what ultimately it does. I'd, however, like to just offer some observations more kind of holistically about the sort of history of the regulation of gun rights in the United States, the politics of gun rights and regulation in the United States, not so much from a constitutional theory or constitutional law perspective, but from a more kind of just general perspective. Right? Not necessarily thinking about it from in a legal way, thinking about it more in a political way. After all, when we do constitutional law, at the end of the day, at least the realists will tell you that ultimately what we're doing is politics, not really law in the first place. And specifically, the question I'd like to reflect on is from the perspective of people who believe that at least some degree of gun regulation would be beneficial and a good idea, right? What, if anything, can they do to mitigate some of the decisions that the court has made, making it more difficult to engage in gun regulation? And in addition, how did we get here, right? How did we arrive in 2023 where all of a sudden a situation that an esteemed Republican, staunch conservative like Justice Berger would have literally and explicitly thought was absurd has turned out 45 years later to be our practical reality. And so I think ultimately there's kind of two obvious answers to that question, one of which is true, but perhaps unrealistic on the short term. The other, I think, of which may at least arguably be somewhat more realistic and feasible from a political perspective. And of course, the first way to change the capacity of the state and federal government to regulate firearms would, of course, be to change the personnel on the Supreme Court. Right? After all, the reason the court, bluntly speaking, the reason the court is reaching the conclusions that it is the result of a many decades-long campaign to get more conservative members on the Supreme Court. And one of the kind of key factors, not the only one, but one of many key factors in selecting the Supreme Court was their perspective on gun rights, right? The recent appointees to the court all made it very explicit before they were appointed, more or less what their take was on the meaning and purpose of the Second Amendment and how they would rule, broadly speaking, should they be presented with Second Amendment related questions. Now, that's of course a possibility. It means people from the liberal side of the country winning more votes, getting more senators in Congress, and getting more of their candidates appointed in the Supreme Court. So I characterize that as a pretty long-term strategy. Right? It's going to take a while. The people on the court now are going to be there for a while, and they're not going to be replaced anytime in the near term, barring court packing or other kinds of fantasies that I think are also, bluntly speaking, unrealistic. Even as much as you might like to see them happen, I don't think it's really a serious option that's on the table. So what can you do instead, right? And one thing I'd like to observe, which I think Josh may have mentioned in passing, but I think is worth really recognizing more directly, that D.C. v. Heller, right, did have a caveat that I think is important, is still kind of floating out there, and is maybe kind of under-recognized and underutilized, insofar as the court said pretty explicitly that it only effectively barred only unreasonable gun regulation, and left open the possibility that reasonable gun regulation could be consistent with the Second Amendment, without really specifying the distinction between reasonable and unreasonable. I actually think that's really important, right? Because from a historical perspective, as Josh pointed out in his talk, without kind of delving into it in more detail, right, we have a very, very long period of time in American history where there was absolutely no litigation over, or frankly, meaningful discussion of the Second Amendment whatsoever. And I think that's interesting and important, right? Why is that? Well, I suspect it's because the overwhelming majority of people, including the overwhelming majority of gun owners, thought that the kind of gun regulation that state and federal governments were doing was by and large pretty reasonable, and they didn't object to it. Therefore, no one was litigating it, right? And in fact, that's a case in point with the one case, United States v. Miller, that was in fact in the 1930s. Now, the background facts are actually really quite complicated. I wrote a paper, my first law review article, which I wrote while I was working, was about it, really kind of just looking into what happens. And it turned out that the case was actually manufactured by the federal government as a method, in part, of testing its authority to regulate firearms. I think in a lot of ways it was also a test by the Roosevelt administration of its ability to just regulate interstate commerce writ large. They were effectively regulating interstate commerce through the taxation clause rather than through the regulation of interstate commerce directly, because they wanted to engage, basically grow the size of the United state. And so the defendant in the case, who was appealing, the district court found that the federal gun law was unconstitutional in the Second Amendment. As a way of teeing up the case for the federal government to litigate it, the man, Jack Miller, was actually dead by the time his own case went before the Supreme Court. He didn't actually have any representation before the court. It was set up essentially for the court to come out with an opinion that was kind of meaningless. And actually, I've been in touch with his granddaughter, who has suggested that, in fact, not only was Jack Miller murdered, but in fact, he may have been murdered by the Oklahoma police So it gets even more complicated, but all that is kind of beside the point. What's really interesting about it was that the gun law in question specifically prohibited the effectively was designed, it's complicated, designed in practice to prohibit effectively the interstate use of machine guns, sawed-off shotguns, and sawed-off rifles. And the perception was that there was a crime wave sweeping the country. Right? This was that era, the kind of the original era of bank robbers, right? There was a huge, and Jack Miller was actually implicated in a number of bank robberies. The concern was that these were weapons used by bank robbers and other criminals in order to engage in criminal activity. Therefore, the federal government was regulating them in order, in effect, to regulate the most dangerous criminals in the country. So why was it that people who were interested in gun rights, like say, for example, the NRA at the time, were not opposed to the Federal Firearms Act? Well, because it seemed pretty reasonable, right? Like regulating machine guns and sawed-off shotguns was not the kind of thing that seemed concerning to your average person who was a typical firearm owner who wanted to have guns for recreational purposes like hunting or self-defense or whatever, right? So why was there so little objection to the Federal Firearms Act? Well, I think it's because it was perceived as being very reasonable regulation, irrespective of what you thought about the federal government engaging in that kind of regulatory activity in general, right? The particular law was not seen as significantly unreasonable. Strikes me that a big problem for proponents of gun regulation is that effectively, I think in a lot of places, people got a little bit cocky about what they were doing and their explanations for why they were doing it. And frankly, I think a big problem for a lot of people on the pro-gun regulation side is that unfortunately, the laws that are coming up before the court seem kind of nuts, right? I mean, like the idea that you would have a gun regulation law that effectively gives carte blanche discretion to the executive to decide who gets to have a gun and who doesn't, effectively telling them you're allowed to discriminate just based on who you like and who you don't like. It's kind of hard to defend a law like that. A law that says effectively you're not allowed to own a gun at all, and we're going to make it so difficult and onerous to own this gun that if we can prosecute you for felony charges simply for putting it together or failing to register at the right time or picking it out of your trunk or whatever. I mean, I think for a lot of people, these come across as extremely unreasonable laws, and I think that ultimately that kind of regulation radicalized people to be more fervently in support of broader gun rights and a very aggressively enforced Second Amendment than, counterfactually speaking, they might have been if the gun regulation in question had been a little bit more sensible and reflected what people actually thought and believed. And this is sort of the observation that I made when writing about the United States v. Miller. Prior to the decision in DC v. Heller was maybe at the end of the day, what we, the kind of regulation that should be permissible is reasonable regulation, and we should have a conversation about what's reasonable and what isn't. I think part of the problem is there is not, or at least hasn't been room for a meeting of the minds over what the majority of people actually think reasonable gun regulation looks like, right? What they think the government ought to be doing and what would make sense for the government to be doing. I observe or hope that if there were more of a meeting of the minds, that perhaps there could be a compromise on some of these questions between people who want to own guns and want to see gun rights protected and people who want to engage in gun regulation in a way that would protect public safety. But I fear that the real politics of the situation have pulled people so far apart that it's going to be really hard to bring them back together again in the center around something that people can compromise.
Yeah, well said. I'll make a related point. I think with politics today, we're sort of a no holds barred, victory at all costs, where those who oppose guns will regulate it even if there's no evidence that actually promotes public safety. And if I could say the other side, with abortion, some of the regulations in abortion are just for the sake of having it, not that there's actually that much support for them. And I think on both issues, everyone sort of goes to their polls, and it does make it harder to have any sort of middle ground. The idea that, again, New York could, in any other context, you can have a library card if we like you. Would anyone think for a minute you can have that? You have a driver's license if you show us you really need to drive, right? That wouldn't fly. But New York defended that law and failed. I think after the Rahimi case, this will sort of settle down. The court will say, okay, this is nuts. You can't have people who are threatening to shoot their girlfriends with a gun. Okay, that might be okay. Maybe some of the red flag laws, you have to have due process requirements built in. You can't just take them away. The length of the order, what sort of process you get from the hearing, that also matters. But I'm not sure that the district is confirmed here. So I think, again, whenever you have a case of Heller or Bruin, it takes some time to settle things out. And hopefully the court does this quickly, sooner rather than later. Let's see some questions. Happy to answer your questions. Yes, sir.
So recently, I know I've been watching the news a little bit on a situation in New Mexico. I don't know if you're familiar with that.
Yeah.
And I know lawsuits are pending because the governor of New Mexico basically banned, I think, in public places, right, carrying firearms. Yeah. And even the Democrat Attorney General came out and said that he wouldn't support her in that process. I was just wondering your thoughts on that.
Right. So if you didn't hear the question, the governor of New Mexico issued an executive order saying that public carry, conceal or open, is no longer allowed, even though state law permits it without permits. So putting aside the Second Amendment for a minute, governors don't have the power to suspend laws. The day of tragedy during COVID, in fact, the governor said that this is a health crisis, just like COVID, so I can suspend laws. Okay, governors do not have the suspension power. In fact, I think they tried to impeach your governor for doing this, but you can't suspend the laws, right? There are public safety laws, but you can't suspend them. Second, even if you have a public emergency law, that doesn't mean you can do whatever you want, right, for indefinite duration. Third, even inside the Second Amendment, New Mexico has a state constitution which guarantees the right to bear arms. So the state law, not even the federal law, prohibits this. And then the Second Amendment, of course, backstops that you can't do this. The governor of New Mexico probably thought, all right, I'm going to do this for 30 days. It'll take a couple, weeks for the litigation to resolve, not just through specific order. What she may not have anticipated was that her own attorney general and other Democrats said, I'm not going to help you. Get your own lawyer. And oh man, she'll get freaked out. It's not going to be hard, right? Lawyers will line to defend her pro bono. That's what happens. But this is a case where a governor saw a wave of shootings, and she said, I will try to ban guns. You think, oh, Josh, this never happens. Well, yeah, I did during COVID. During the pandemic, many states actually banned the sale of guns. Not exactly. What they did was actually very curious. It said, the sale of guns is not an essential service, and since essential gun stores have to close. There's this weird situation in New York, for example, where Walmart sold guns, they could say open door store, but gun shops had to close. Other stores banned gun sales altogether. And I can tell you, during the early days of COVID, a lot of people said, uh-oh, I am scared. What the hell's going on? I want a gun. Actually, if you look at the number of background checks, it's shot up in 2020, early 2020, shot through the roof. And so a number of states have actually said that you cannot ban and sell firearms during some sort of national state of emergency. I think that's good legislation. But it always happens that when there's an emergency, the first inclination of government is to say, okay, no more guns. Let the government guns, you guys can't have them. So the next situation I think will resolve quickly. There are all these lawsuits pending. What she'll try to do is probably rescind the order by herself and try to avoid having to pay attorney's fees. We'll see what the courts will do attorney's fees. That's actually what this actually matters, because bringing a lawsuit is not free, right? It costs money. Even if it's a pro bono lawyer, it's costing them also pay the vendor fees and maybe some damages also. Thank you for the question.
My question is sort of about the Bruin test and analogous logic. Wouldn't judges who wish to, say, regulate the sale of firearms to felons, violent or non, have a fairly good analogy in the disenfranchisement of felon, the disenfranchisement of all felons, to say you have removed yourself from polite society, proven you don't respect the laws, then maybe it's in the best interest of the state and all the people who it protects to not have felons, period, own guns.
Right. So, 2 points. People like when I say this, I'll say it anyway. The Constitution doesn't actually protect the right to vote. Read it very carefully. It says you can't disenfranchise someone based on their race, or based on their age, or based on their sex. There's no further grant of the right to vote. The right to vote is considered a fully political right, which can be given or received at the largesse of the state. The right to vote is a civil right, protected by the Constitution. I think they're actually in very different stead. Justice Barrett made this point in her confirmation hearing, and she got squirted. How dare you say there's no right to vote? Yeah, there is. You like to say the right to vote is in the Constitution. Read it. Maybe your state constitution grants it. It's not the federal Constitution. Moreover, the laws actually do, the Constitution does consider that certain felons will lose their rights. And it is considered in the 15th Amendment otherwise that you might lose your right to vote on account of conviction. I don't think the Second Amendment has a similar tradition. But look, you can say that any sort of crime disenfranchises you forever, for free speech, for religion, and so on. So I think the analogy doesn't hold up. Exactly. Good question. Yeah. Yeah. One more. Yeah.
So I was just going with the case in front of us about pretrial condition, if that no conviction. Are there other rights that have been, sometimes you say you can't post Trump's trials and you can't post, and Steve Friedman can't post online.
Yeah.
If he was to evict that, though he's not worthy of conviction, is that other cases that they can pull in to remain as a innocent?
Yeah, it's a good question. So often when you're perhaps pending trial, there's certain limitations on your rights. So for example, gag orders, right? You can't tweet about your case, you can't talk to witnesses, you can't pressure other people. Search and seizure. If you are under trial, you might supervise a condition of bail if you search at any time without a warrant, right? And if you fail to, if you have something on your person, they can call you in. So there is some deprivation of rights pending trial. With the DVRO, though, it's not even an indictment. It's not even charged with a crime. It's just because you told the judge might be dangerous. That's often a one-sided presentation. And I think what people have to say is there must be some sort of due process to ensure this is not just a railroad person where you have a DVRO and they never actually charge you back and it goes up for years. Okay, are we done, Caleb?
Maybe
One more.
I mean, I would just say,
Go for it.
I would say in addition to that, I mean, like, I would put as like an analogy to something like your 14th Amendment rights against search and seizure, right? You can get a warrant in a particular fashion. It's not like you have a due process right there. You can test a warrant before it's granted. It doesn't seem to me unreasonable, as it were, for a judge to make a finding that a particular person is in fact dangerous based on a showing of the facts, and therefore having them own a gun crime is a reasonable kind of regulation. And I think a lot of people, most people, many people, I don't know, a lot of people, in my personal opinion, would likely be sympathetic to a position along those lines, right? That even if you think gun rights should be protected and are protected by the Second Amendment, if you make a finding that this person is in fact dangerous and is likely to use the gun to kill people, you can take the gun away from them before they do it.
Okay, last question, Aaron.
Yeah, it's for Professor Fry. I'm assuming your premise that gun regulation somehow curtails gun violence, and that's your purpose for wanting it. I just was curious as to your position, or maybe your thoughts, if we consider areas that are heavily regulated in terms of guns and the overwhelming prevalence of gun violence in those particular areas, as distinct from rural places where there's comparatively very low gun violence. I just wondered if you said, if you're assuming the premise that gun regulation reduces gun violence, and that's demonstrably not the case, why would it be something of interest to you?
Well, I guess I'm not sure. I think it's helpful to kind of think about gun regulation in the abstract, right? I mean, I think it ought to be
I'm
uncontroversial.
I'm asking a particular question, well, not abstract at all.
Sure, but what I'm saying is, it seems to me at least plausible that it's possible that some forms of gun regulation might reduce gun violence to some degree, right? I'm going to make a super weak claim here. It is conceivable to me that some form of gun regulation might in fact mitigate some degree of violence. It seems to me like if you can empirically point to regulation that seems to have that effect, it seems unproblematic to me to think that that's a reasonable thing to do. I mean, we regulate other fundamental rights on similar grounds, right? And we have very robust First Amendment protections. It doesn't mean that every regulation of speech is unconstitutional, right? Some regulations of speech are constitutional, like, for example, regulating defamation. Absolutely constitutional because we can do harms, right? We do findings about what those harms are. We say this is a kind of speech that you are not permitted to engage in because we recognize that it's harmful, and therefore we prohibit you from doing it. It seems to be like at the very least, right? Even if you think there should be a robust Second Amendment, right? There's at least some conceivable room for regulation that can be publicly beneficial.
And I think we're out of time. We can come chat later. Thank you.
Thank you, everybody. Appreciate our speakers coming. Next event's in 2 weeks. We have an Originalism and Living Constitution panel. So we have Professor Schaub here at UK coming, Professor Strang from the University of Toledo, and then UK graduate Cody Barnett, Supreme Court litigator and counsel to ADF. So see you in 2 weeks.